whether there was some reasonable cause or not, and whether it is good. There are the two important points. The other point, which is not really in the law, but which is essential. You have to fix responsibility on a person. Merely because there is a delay, and if you cannot fix responsibility on a person, it's impossible. You cannot really penalize.
Are there any views?
I know this is a subject on which most of us have very strong opinions, and especially the civil society. But I think there should be an evaluation as to how this, shall we say, slightly lenient attitude of, so-called lenient attitude of the commissions has had an impact on getting the information to the people. Because I think this issue is getting more important than is due to it. But so far as I'll begin with the last point. See, when you are holding a hearing, in fact, after the information is provided, because I have always had in Karnataka Information Commission that our first duty is to get the information to the person. Once we have got the information, we immediately come to the hearing and say, what was the cause? Now, if there is a reasonable cause, we don't issue notice, because as Mr. Gandhi said, in fact, penalty proceedings take much more time than the case. And if they keep on multiplying, we would have had 2 times, 3 times the pendency that we have. So we know. Now, most of the cases we have found, PIO is just the front man, as he said. He is not the custodian of the information. And in some cases, he is prevented from giving the information. In such case, we have, in several cases, asked him, who is the person who has prevented you and was not giving you the information? The file may be with somebody else. Now, in that case, we have made in the deemed PIO, because there is no point in issuing notice to that particular person. We have, if the case is serious, we have made in the deemed PIO and we said, you come before us. No matter what is the status of that particular person. We said, the information is with you. And if you have not provided the information, then we have to deal with you. Now, most of the cases, what we find is, the files are not ready. Now, what would you do? You get into a very complicated system of finding out what really happened to the file. In fact, information in such cases is not provided. And the persons are there. There is a question of delay. The information itself is not there. Then you get into who was the person when was the file last seen? Who was the person who was in charge of it? You get into a very, very long investigation sort of procedure, which again takes a very long time. You keep on summoning one person after the other, retired person, who is the person? And one Tahsildar who appeared before us, not the PIO, he said, so far as Bangalore is concerned, 70% of the land records are missing. And out of the 30% that I hold, most of them are fabricated records. And these people are coming to me to get a copy of the fabricated records so that they can produce in the court as true. So they have got the records replaced in the, this is the system in which we are working, whether we acknowledge it or not. He said, most of the records in my office have been fabricated and placed as original records, and they are asking me for copies of these records. Now, an inquiry was started in Bangalore on that how could this fabricated record got placed. But this thing has taken such gigantic proportion that it's very difficult to control. Second, which we found and to which we remedied slightly, is the application may be too long. In some cases, they are asked for 300 pieces of information. Now, whatever you may do, the information provided will be absolutely incomplete. In such cases, it becomes very difficult for us to levy a penalty, especially considering the fact, in fact, sometimes what we feel is the fellow is in front of us. He said, I have tried myself. I could not reply to all the information that he has asked for. you can still technically levy a penalty. But when you levy a penalty, in fact we found that if the fellow is corrupt, then 25,000 rupees is absolutely meaningless for him, even he can just pay her. And if a fellow is honest, it's a death knell for him, you can't in any case recover it in one go. So we say 5,000 rupees per month. But if his salary is 7,000 rupees and you deduct 5,000 rupees, then there is no way his family is going to get a meal for 5 days. So sometimes these are extraneous considerations, but sometimes we have been moved by that also. Then, and lastly I would say, we found that if we were to follow the procedure, in fact, our local Justice Hagade said in one of the symposiums, he said, you need not issue a show cause notice, just hear him out and impose penalty. But then we had the benefit of advice of another Chief Justice of the Supreme Court, Justice Verma, and he said, no, you have to issue a show cause notice, you have to do it. And if you have to do that, we find that it becomes a very lengthy procedure, especially if you follow it and all. So there are certain limitations, but to my mind, in fact, one of the activists, well-meaning person, he said, you must really levy maximum penalty in all the cases so that the people get terrorized. So I said, look, we are commissioners, we are not terrorists. So we just terrorists, he just gets a machine gun and shoots everybody on his side. Now we said, that's not the policy that we really want to adopt. We want to use this clause judicially. And I think there is a fear that if we don't give information within 30 days, we will be better. Now, that being so, personally I feel you have a very good other 2 points also. Basically, delays and backlog. More relevant so far as the commissions are concerned, on which also maybe the other people should throw some light. And this particular issue, if you can get a study conducted and find out whether it is really hampering the cause of the right to information. Because to my mind, and I also made a few applications after I retired, mostly the good organizations are sending a reply within 30 days. Thank you.
Regarding penalty, I think what Mr. Saab said, I totally agree with it. The way they are conducting and hearing, same thing, we also follow it. But sometimes, I want to add, the PIOs, they are unable to provide information, and delays due to the applicants ask voluminous information. In such case, they, frankly tell us, look, this much information I cannot gather within this time, sir. So that's why delay is made. I think it has got a very, very reasonable ground to consider not to, impose penalty. In such cases, sometimes it also happens, the information is so voluminous, and then the applicant cannot pay the amount also. Sometimes it runs more than the lakhs. So I said, then why you are asking, this much information, you should have asked at least the information which you want, but not the whole office. So that is another problem we face with, faced by the commission. In some cases, of course, I sorted out. When all the parties there, I asked the PIO whether you allow him to inspect all records, and whatever the documents he requires, let him take note of it. And if applicants also agree, I think this way some solution has been given by us also. So this is one of the reasons. Then in one occasion, same thing that the PIO said, sir, I have been asked not to punish by the higher authority. Since in that fact, he filed affidavit and that it has been and I'll summon him. Then he was summoned, yes. So he agreed also, yes, we have not told him not to give. Then case I think we have made him deemed PIO. And then generally in hearing itself and conducting the hearing, the both the party they argue. In that case, we know what are the reasons for the delay, and especially if there is a reasonable ground. To me, according to my opinion, it is not necessary to issue so-called notice. But where it is there is no reasonable grounds, it is even it is established fact that the PIO has deliberately done, malafidely denied the information or delayed. In that case, we forward we issue so-called notice, and his reply is not satisfied. So generally we impose penalty. And there are also some cases, though so-called notice has been being issued, and then reply was very satisfactory, with reasons and then with substantiating proof. So we don't issue it. So that is it. Thank you.
Incidentally, we don't issue a show cause notice. In the order itself, we write. Through a copy of this order, we hereby ask you to show cause and all. Separate show cause notice.
I want to add to what Mr. Mishra said earlier. Yes, show cause proceedings are really time consuming. To just give an example, in my case, we conduct about 150 show causes every month, somewhere in that region. More than that, we don't have the capability. So there is also a slight selectiveness saying, look, if in every case we issue a show cause, we will not be able to do this. And it converts to about 10 to 15 penalties in a month. Now the question is, should we be doing more of this and therefore less of these cases? As he says, there is a lot of time that really goes, because quite often you get a person, then he says, sir, I wasn't there, something else happened, you have to call the next person and so on. So I think that's
right. No, just taking it forward, as many people, many honorable commissioners are saying that the issue of show cause notice is only done after the reasonableness has been examined. Fair enough. But can a paragraph be added at the end of the order? Even if the show cause is not being, it's being said, it can be assumed that when the hearing is taking place, many of the facts do come to light, and the commissioner can conclude that there is a reasonableness or there is not a reasonableness. The prima facie, it is possible to. So, can a paragraph be just added at the end of that order, saying that this man says that he did not, the delay took place because of this reason, and the commission feels that this is a reasonable cause, and therefore no show cause or penalty proceedings are not being proceeded. That one paragraph will not add to the amount of the work, which the point that you
sorry, I mentioned two things. I also mentioned another reason where we are not able to impose penalties, where we cannot pinpoint the responsibility. This is there in at least 30-40%